Good afternoon, everyone. Today's topic for my lecture delivery is adoption laws in India. Finally, we'll look into the adoption process and what all adoption is. Adoption is a process other than the birth process, which creates parent and child relationship. It is a social and legal process by which a child of one set of parents becomes the child of another set of parents or parent. Traditionally, a child was adopted for spiritual purposes, and now adoption is also done to satisfy the emotional and parental instinct of the adopters. According to Juvenile Justice Care and Protection of Children's Act of 2006, adoption was defined as the process through which the adopted child is permanently separated from the biological parents and becomes the legitimate child of the adopted parent with all rights, privileges, and responsibilities that are attached to the relationship. This act introduced the expression child in need of care and protection. The importance given to sonship resulted in development of concept of adoption. The legal procedure by which legal relationship between a child and his or her biological parents are terminated and a new parent-child relationship is initiated is called adoption. Further, we'll look into the history of adoption, how adoption as a term, as a process came into existence. We'll first see it traces back to an adoption can be found as in ancient Rome under 6th century AD Roman law, Codex Justinus, when the family patriarch was poised to die without a male heir, an heir could be provided from another family through adoption. Families with many sons often adopted their sons to the noble families in order to forge a coveted family connection. If a family had too many sons, the family's wealth would be spread too thin. Not enough sons and the wealth might revert back to the state. By adopting one another's son, the Roman nobility ensured the wealth would stay within a few desirable families, and each of those families' sons would receive a good inheritance. Because wealth and power passed down through the paternal line, daughters were seldom adopted. Adoption further continued in the vein well into the Byzantine Empire, that is in 330 to 1453. But in the late Middle Ages, 1300 to 1500, the rules began to change. French law highly discouraged adoption process as Italians, English common law also forbidded the adoption. The reason for the shift in policy is that in Middle Ages, inheritance was redefined to include only those related by blood. This was done in an attempt to keep the ruling royal families in both power and financial influence. At the same time, the practice of oblation began wherein children were left at a convent or monastery and then adopted by that religious outpost. The convent or monastery would care for the child, and as the child grew up, the child would serve that order. As the number of abandoned children grew, the church began to regulate the practice, leading to the first official orphanages in Europe. Further, in 1851, we see that the Massachusetts Adoption of Children Act became the first adoption law to protect the interest of the child. The statute required a judge to determine if the adoptive parents had the consent of the biological parents or guardians of the adoptee. Furthermore, the adoptive parents had to prove a sufficient ability to bring up the adoptee and to provide them a suitable education. The approval of the adoption was left on the discretion of the judge, cementing adoption as a state issue rather than a federal issue. The Civil War brought a halt to most adoptions, which led to the overcrowding of many US orphanages. In 1854, Charles Loring Brace, director of the New York Children's Aid Society, came up with the idea of orphan trains to move orphaned and abandoned children from the urban areas like New York City to rural areas of the Midwest. The estimated 120,000 children were not adopted by their families in the Midwest, and many went into the indentured servitude effectively. Though the orphan trains existed under questionable circumstances, they did lay the foundation for the idea of modern foster care. In 1891, Michigan became the first state to require that a judge approve of the prospective adoptive parents' moral character and ability to support and educate a child. A few other states began to pass legislation on adoption. Then, in 1909, at the first White House Conference on the Care of Dependent Children, President Theodore Roosevelt recommended moving away from child institutional care. This resulted in even more states passing laws regulating adoption and the founding of the first US adoption agencies in 1910. Adoption became even further regulated with the Minnesota Law of 1917. The Minnesota Law was the first to mandate home studies and became the foundation from which the child welfare agencies would conduct pre and post placement adoption reports. The law also marked adoption records as confidential, accessible only by the children and adults, birth family, and adoptive family directly involved in the adoption. Further, we'll move as to trace back history of adoption in India. In India, adoption has been experienced for 1,000 years. Historically, when there is a lack of male offspring occurred, couples went for adoption of a male child to title him as a lawful heir after the death of the adoptive parents. According to Hindu tradition, if person has a son to light the funeral fire, then salvation will be easily achieved through sons who offer ancestral worship. In ancient systems of law, only Romans and Hindus provided for an organized institution of adoption. Under both these systems, primary objective of adoption was to provide a child to childless and continue to the life. According to Manu, an adopted son shall never take the family name and estate of his natural father. The funeral cake follows the family name and the estate, the funeral offerings of him who gives the son in adoption ceases as far as the son is concerned. Adoption as a legal notion in India was previously exclusively open to those who belonged to the Hindu group. The creation of the Uniform Civil Code was hampered in the past by the adoption laws, reliance on religion to justify practices that were unfair to children in the manner contemplated by Article 44 of the Constitution. The Guardians and Wards Act 1890, which by secular means rendered the kid a ward and not an adopted child, gave rise to the initiation rituals in 1890. The fact that Jews, Parsis, Christians, and Muslims do not recognize total adoption has been a significant barrier. Further, we'll move on to what all are the conditions for adoption. The prospective adoptive parent shall be physically, mentally, and emotionally stable, financially capable, and shall not have any life-threatening medical conditions. Second, any prospective adoptive parents, irrespective of his marital status and whether or not he has biological son or daughter, can adopt a child subject to the following, namely, these are: the consent of both the spouses for the adoption shall be required in case of a married couple. A single female can adopt a child of any gender, and a single male shall not be eligible to adopt a girl child. Third, no child shall be given in adoption to a couple unless they have at least 2 years of stable marital relationship. Fourth, the age of prospective adoptive parents as on the date of registration shall be counted for deciding the eligibility and the eligibility of prospective adoptive parents to apply for children of different age groups. In case of couple, the composite age of the prospective adoptive parents shall be counted. The minimum age difference between the child and either of the prospective adoptive parents shall not be less than 25 years. 7. The age criteria for prospective adoptive parents shall not be applicable in case of relative or adoption and adoption by step parent. 8. Couples with 3 or more children shall not be considered for adoption except in case of special need children as defined in sub-regulation 21 of regulation 2. Had to place children as mentioned in regulation 50 and in case of relative adoption and adoption by step parent. Further, how adoption is done, what all are the procedure, we'll see here. Step 1, that is registration. Prospective adoptive parents need to get registered with an authorized agency. Recognized Indian Placement Agencies RIPA and Special Adoption Agency SPA are the agencies which are allowed to make such registrations in India. The prospective adoptive parents can visit the adoption coordination agency in their area where the social worker will explain the process and take you through the formalities, paperwork, and general preparations required for registration. Step 2, home study and counseling. A social worker for the registration agency will make a visit to the home of the prospective adoptive parent in order to do a home study. The agency might also need the parents to attend counseling sessions in order to understand the motivation, preparation, strength, and weaknesses of the prospective parents. As per Central Adoption Resources Authority, CARA, regulations, the home study need to be completed within 3 months from the date of registration. The conclusion from the home study and counseling session is then reported in the Honorable Court. Step 3, referral of the child. The agency shall intimate the interested couple whenever there is a child ready for adoption. The agency will share medical reports, physical examination reports, and other all relevant information with the couple and also allow them to spend time with the child once they are comfortable with the details shared. Step 4, acceptance of the child. Once the parents are comfortable with the child, they will have to sign a few documents pertaining to the acceptance of a child. Step 5, filing of petition. All necessary documents are submitted to a lawyer who prepares a petition to be presented in the court. Once petition is ready, the adoptive parents will have to visit the court and sign the petition in front of the court officer. Step 6, pre-adoption foster care. Once the petition is signed in the court, the adoptive parent can take the child to a pre-adoption foster care center and understand the habits of the child from the nursing staff before taking the child home. Step 7, court hearings. The parents have to attend the court hearing along with the child. The hearing is held in a closed room with a judge. The judge may ask a few questions and will mention the amount which needs to be invested in the name of the child. Step 8, court order. Once the receipt of investment is made is shown, the judge shall pass the adoption orders. Step 9, follow-up. Post completion of the adoption, the agency needs to submit follow-up reports to the court on the child's well-being. This may continue for 1 to 2 years. We'll also look into how inter-country adoptions are done. As we know, every child has a right to love and be loved and to grow up in an atmosphere of love and affection and of moral and material security. And this is only possible if the child is brought up in a family. The most congenial environment would, of course, be that of the family of his biological parents. But if for any reasons this is not possible for the biological parents or other near relative to look after the child, or the child is abandoned and it is either not possible to trace the parents or parents are not willing to take care of the child, the next best alternative would be to find adoptive parents for the child so that the child can grow up under the loving care and attention of the adoptive parents. The practice of inter-country adoption came about largely as a humane response to the plight of war orphans and the abandoned children of servicemen in World War II, the Korean War, and Vietnam War. Today, the main receiving countries are the US, Canada, and the developed countries of Western Europe. Factors such as the decline in fertility associated with stalling marriage, the limited success rate and high cost of infertility treatment, and a lack of domestic adoption opportunities have made inter-country adoption as an alternative to childless couples in the receiving countries. However, in states of origin or sending countries, extreme poverty, lack of contraceptions, and society's attitude to birth of illegitimate children are 3 major factors leading to the abandonment of children to institution. The concept of male child also leads to the abandonment of the girl child, which is an unfortunate reality of our own country. Then next, there is a question whether same-sex couple can do adoption. Then in this reference, we can say that LGBT adoption refers to the Adoption of kids or childs by LGBT plus community, that are lesbian, gay, bisexual, and transgender individuals. This could take the shape of same-sex couple adopting a kid together, one member of a same-sex marriage adopting the other's biological child, a stepchild adoption, or a single LGBT plus individual adopting a child. In addition to 27 nations, a number of subnational entities and dependent territories, joint adoption by same-sex couple is authorized. Additionally, in 5 nations, adopting a stepchild is permissible for same-sex couples. Due to the fact that constitution and statutes typically do not address the rights of LGBT people with regards to adoption, legal rulings frequently determine whether they are able to parent either separately or together. LGBT parenting, according to many who oppose it, has negative effects on kids and parents. There are significant associations for mental health specialists in US, Canada, and Australia. No solid empirical study is still found that supports the opposites have been found. There are only a few ways for same-sex couple to become parents. The adoption attempts by same-sex couple can be made as a joint adoption, a second parent adoption, or an equitable adoption. Even though societal groups have very different views on the subject of same-sex adoption, same-sex families do exist and same-sex couples are also existing, but adoption is still tough for them. Next, we will look into some adoption laws in India. In India, there is no uniformity in adoption law. It is applicable to all Indians. According to Hindu Adoption and Maintenance Act 1956, a woman who has attained the age of majority, widowed or divorced, can adopt a son or daughter. Married women can also adopt under certain circumstances. This act allowed the adoption of a daughter. Also under the old law, only parent can give child in adoption. Now, even a guardian with permission of court can give the child in adoption. Adoption is purely secular act under the present law with the permission of court. However, Hindu Adoption and Maintenance Act provides adoption for Hindu child. Only other communities have resort to Guardians and Wards Act 1890, where they became guardians of the child. And when the children turn 21 years of age, they no longer remain wards and assume individual identities. Similarly, according to Juvenile Justice, Care and Protection of Children Act 2000, adoption is an important process in the rehabilitation and social integration of children who are abandoned, orphaned, neglected, or abused in their families or institutions. In 1992, the government of Tamil Nadu introduced a scheme called Cradle Baby Scheme. This initiative was stated to bring down the shocking number of female infanticide. The Cradle Baby Scheme has brought down the number of female infanticide in some extreme rural areas of Tamil Nadu, and this also seems to be a factor for the increase in number of female children in that state. Now we will see a case, Shabana Hashmi versus Union of India. Facts of this case are, in the year 1996, Shabana Hashmi along with her husband adopted girl child. While adopting her daughter, the couple was informed that the Muslim personal law does not allow adoption and do not consider adopted child at par with the natural born child. Thus, this PIL under Article 32 of Constitution was filed to recognize the right to adopt as a fundamental right. Some issues were framed by like whether the adoption of a child is a fundamental right or not. Second, in case of contradiction between personal law and secular law, what is going to be prevailed? Third, whether caste, creed, and religion affects the adoption procedure or not. Some arguments were submitted by both petitioner and respondent. First, we'll see what petitioner sides say. Petitioner requested the court to lay down optional guidelines enabling adoption of children by persons irrespective of religion, caste, creed, etc. And further, for a direction to the respondent Union of India to enact an optional law, the prime focus of which is the child with considerable like religion, etc., taking as a hind seat. It was also highlighted that as per guidelines of 2011 and JJ rules 2017, there is undue delay in processing of adoption cases at the level of child welfare committees, the adoption recommendation committees, as well as the concerned courts. It was also argued by the petitioner that the JJ Act 2000 is a secular law. enabling any person, irrespective of the religion he professes, to take a child in adoption. It was also argued that the court should direct the states and duties under JJ Act 2000 to implement Section 41 of the Act and to follow CARA guidelines. And lastly, it was argued that right to adopt should be maintained as a fundamental right. Let's move on to respondents' argument. They argued that it is contended that Islamic law doesn't recognize an adopted child to be a par with a biological child. As per Islamic law, it processes what is known as kafala system, under which the child is placed under a kafil who provides for the well-being of the child, remains the true descendant of his biological parents and not of the adoptive parents. It was also contended that this system is recognized in UN Convention on Rights of the Child, and therefore direction should be issued to the CWC, that is Child Welfare Committee, to keep in mind and follow the principles of Islamic law before declaring a Muslim child available for adoption under Section 41, Clause 5 of the JJ Act 2000. Further, court gave in the judgment highlighted some points. They are: it will now be relevant to take note of the stand of the Union of India. Way back on 15th of May 2006, the Union in its counter affidavit had informed the court that prospective parents, irrespective of their religious backgrounds, are free to access the provisions of the Act for adoption of children after following the procedure prescribed. The progress on the ground as laid before the court by the Union of India through the Ministry of Women and Child Development may also be noticed at this age. The JJ Act 2000 as amended is an enabling legislation that gives a prospective parent the option of adoption an eligible child by following the procedure prescribed by the Act, rules and the CARA guidelines as notified under the Act. The Act does not mandate any compulsive action by any prospective parent, leaving such person with the liberty of accessing the provisions of this Act if he so desires. Such a person is always free to adopt or choose not to do so, and instead follow what he comprehends to be the dictates of the personal law applicable to him. To us, the Act is a small step in reaching the goal of Article 44 of Constitution, and personal beliefs and faiths, thoughts must be honored and cannot dictate the operations of the provisions of the enabling statute. The decision of this court in Lakshmikant Pandey is a landmark in the development of the law relating to adoption. Dealing with inter-country adoptions, elaborate guidelines had been laid by this court to protect and further the interest of the child. A regulatory body, Central Adoption Resources Agency, also known as CARA, was recommended for creation and accordingly set up by the Government of India in the year 1989. Since then, the said body has been playing a pivotal role laying down norms, both substantive and procedural, in the matter of inter as well as within the country adoption. Lastly, no doubt that adoption is a secular concept. It gives birth to a huge responsibility on adoptive parents, and also it is a big change for adoptive child. In our society, religion plays a very big role in each and every aspect. In adoption, adoptive child will follow all the religion, customs, traditions, values of the adoptive family as a secular concept which is different from the Muslim personal law. First of all, in case a Hindu boy being adopted by a Muslim family, he won't be able to enjoy the secular benefit. It is unfair with that adoptive child who is not able to understand the further consequences of adoption. It adversely affects the rights of the adoptive child. Second, a newborn baby can be shaped to any form, but if a child above the age of 5 years with Hindu practices being adopted by a Muslim family, then he will himself feel very uncomfortable. It might be a possibility that the adoptive family won't be able to accept the child completely because of his or her religion, which makes it unfair for the child. Therefore, it is very important even to consider the religion in adoption process. We should neither neglect the religion of adopted child nor of adoptive parents. Thank you.